Hello, everybody. Welcome to this webinar on music copyright in the age of AI. My name is Ed Phelan. I'm the Knowledge Hub and Resources Manager here at the ISM. Please feel free to introduce yourself in the chat, let us know where you're coming from, and say hello to everyone else attending. We have a Q&A function, so please do ask questions. We'll come back to them later on in the webinar. For the purpose of accessibility, I'm a white male with blonde hair wearing a black t-shirt with a white logo behind me. So we're going to hand over to Charlotte O'Mara, who is a music and media lawyer, who is going to explain music copyright in the age of AI. This webinar will be recorded and sent out afterwards. Thank you, and looking forward to talking to everyone later. Over to Charlotte.
Thank you, Ed. Thanks very much. And good afternoon, everybody. As Ed has said, my name is Charlotte O'Mara, and I'm a music and media lawyer at Gunnar Cook LLP. And for the accessibility purposes, I have dark hair and a black top today with a dark background behind me. So today we're looking at music. Thanks, Ella. So today we're looking at music in the age of AI, the challenges, copyright licensing, and responsibilities. And I just specify that this is not formal legal advice, but just some proposals and thoughts on the current situation. So, as many of you know, artificial intelligence is transforming the music industry. It's reshaping how songs are composed, produced, distributed, and monetized. Generative AI can create entirely new tracks, emulate famous artist styles, and even produce lifelike recordings of instruments or voices that never existed. So for musicians, composers, producers, labels, and the music industry as a whole, this revolution offers new creative possibilities, but also profound legal and professional challenges. The law is struggling to keep pace, and rights holders need to navigate a complex landscape at the moment, covering copyright in training data, authorship and copyright in AI outputs, licensing obligations, and ethical responsibilities. Here we're going to aim to break down the key issues, hopefully in plain English. In the UK, there's a unique mix of existing copyright rules, including a computer-generated works provision, and recent government consultations and urgent industry lobbying means that anyone working with generative AI should look at two linked problems. Number one is the inputs used to train or prompt AI models, copyright and licensing in relation to that, and two, the outputs those models produce, and authorship, copyright and licensing in relation to that. So these issues prompt questions: can copyright adapt in an AI world? Can AI and traditional music exist together and still respect intellectual property rights, ensuring consent, correct crediting, and fair remuneration, while still enabling exciting innovation in the music industry? So just staying on this slide, if we look at the two big copyright challenges, the first one being inputs and training data. So AI music models are often trained on vast data sets of existing works. Sound recordings, musical compositions, lyrics, stems, and metadata. Copying these materials, even temporarily, may require a license unless an exception applies. In the UK, under the Copyright Designs and Patents Act 1988, or the CDPA, which I'll shorten it to here, sound recordings in the main are protected for 70 years from the end of the calendar year in which it was released, and rights holders, often the artists and labels, control the copyright. For musical works and lyrics, these are protected for the life of the author and until 70 years from the end of the calendar year in which the last author dies. Rights holders such as composers and publishers control the copyright. So there is currently ongoing legal tension in this area. AI training often involves systematic large-scale copying, unlike human influence through listening, which is often seen as an argument for AI. And this systematic large-scale copying can infringe copyright even if no literal sample appears in the final output. So if we look a bit closer at inputs and the rights picture for training data and prompts, what counts as input, for example, inputs can include entire sound recordings, musical compositions, stems, lyrics, metadata, and even short audio video clips that are used to build and fine-tune or prompt generative AI models. Using those materials may involve copying and thus copyright infringement risk, even if the copy is transient or used only for analysis. However, just a side point here, there is some debate over whether training actually constitutes copying, but that's another point. So copyright and data mining exceptions. The UK government ran a full consultation, as many of you may know, on copyright and AI between December 24 and February 25, and has proposed changes that would allow broader use of copyrighted material for AI training, subject to technical transparency and a rights reservation or opt-out mechanism. That process is active and has already prompted strong industry responses. Major music industry bodies such as the Musicians Union, BPI, UK Music, and many high-profile artists have warned that permitting unrestricted training on recordings and compositions, even with an opt-out, would harm creators and be effectively unenforceable in practice. Those groups have been pushing for a licensing or remuneration model and for clearer transparency obligations on AI companies. So that's the background picture, but what does this mean commercially right now in the UK? Well, at the moment, but this could be subject to change in the near future, training commercial AI machines using copyrighted works without a license is probably infringing copyright by making copies as part of the training process. There are limited exceptions. For example, for non-commercial research under Section 29A of the CDBA, the text and data mining exception, and fair dealing in the UK. However, input training is unlikely to be considered an exception at the moment. Therefore, it is advised to treat training on copyrighted music as potentially infringing unless there is a license in place, which we'll look at a bit more later, or a clear statutory exception that actually applies. However, there are clearly issues around input training. Unfortunately, there is a lack of transparency over data, lack of transparency over the data used for training AI, and used for training AI tools. So therefore, it's difficult to know whether copyright works have been used and which works have been used, making it very difficult to prove infringement. Using the output from an AI tool, so the music created from a trained AI tool, for example, as evidence of infringement, requires using reverse engineering tools to try and determine whether copyright works have been used in the input process. Again, this is very difficult to do. There are also territory issues. in the UK, to enforce copyright infringement proceedings, the infringing act usually needs to have taken place in the UK. This may be difficult to show, and indeed seems to have caused some problems with the current prominent case on AI and copyright infringement being brought by Getty Images against Stability AI. A part of the claim has been withdrawn due to territory issues. In addition, different territories have different laws in this area. In the US, there is a much broader fair use exception than the UK's fair dealing. And in the EU, the AI Act has introduced an opt-out provision, so that even if there is no license in place, the AI tool trainers can train on copyrighted works provided they can legally access them, and provided the copyright owner has not opted out of allowing this. This is controversial, and despite initial pushes to do so, the UK has not yet adopted an opt-out system, but it is still under consideration. AI tool trainers may look to do their training in different jurisdictions to try and avoid infringement issues. The next slide, please. So that's some of the issues. Let's take a closer look at licensing input and how you might try and protect works from unauthorized use in input training. This is a really interesting question, which is still surrounded by much uncertainty. Because UK law currently has no broad commercial text and data mining or TDM exception, commercial training on protected works normally requires a license. Currently, there is no agreement over the best way to do this in a way that allows for innovation, whilst also protecting the rights of creatives and rights holders, ensuring compliance with the law and fair remuneration. So there's been many calls for mandatory licensing by AI developers, the use of copyright material in training, development of blocking, filtering systems for both certain input prompts and for output to prevent reproduction of copyrighted music, and for greater transparency and infringement reporting obligations with robust enforcement and penalties. So some potential considerations for the best way to do this licensing system going forward include direct licenses from labels, publishers, or independent artists. So this would mean contractual provisions covering AI and licensing, for example, contracts between artists and labels or composers and publishers clearly reserving rights and stating that any AI use is subject to explicit approval and separate license and fees. And AI developers would need to obtain direct licenses from the rights holders. However, in practice, labels and publishers, for example, may look to license whole catalogues for such uses rather than individual consents. So it's something to be looked at further, I would think. Some other proposals for dealing with this licensing issue around input are licensed dataset providers and collective licensing solutions. For collective training licenses, centralized schemes have been proposed that offer scale and simplified clearance for AI model builders with remuneration via license fees. These types of licenses could be exclusive or non-exclusive dataset licenses negotiated with labels and publishers or collective licensing bodies. These could specify permitted uses. For example, it could be used for training, commercialization, redistribution, and they could specify the duration, the territory, and kind of payment, which may, for example, be upfront fees, royalties or revenue share. In fact, some AI developers are already doing this and have entered into licensing deals with music publishers and record labels, for example. There's also been 2 component licensing models have been suggested in relation to AI use and music. One license for input training, involving a share for creatives in all the economic benefits of the AI providers, such as a share of their subscription fees or other revenues. And then another license for subsequent commercial use of the output, where a share for the creatives in all the economic benefits that may arise from the subsequent use of AI-generated music. Proposals for remuneration to creatives have include various proposals, such as tax-based models and also levy-based models, where AI providers contribute some of the advertising or subscription, as we were saying, to creators, and also potentially licensing fees from via DSPs, or an AI royalty fund managed by a collective, for example. These are all still being explored at the moment. In relation, just have a little further look at the proposed opt-out system and how this could work in practice. As mentioned, discussion is ongoing on these proposals. The opt-out system, perhaps similar to the EU law at the moment. Practical proposals for how creators could signal no AI use. These include through machine-readable metadata. For example, no AI tags in files, and AI crawlers being required by law to check and respect this, and also licensing terms in online platform settings. Streaming or distribution services, for example, platforms like YouTube and Bandcamp could offer a no AI use setting. Proposals for what this might look like in practice would be that the artist uploads the song to streaming service, they choose a no AI use setting in the account settings, and the platform embeds the no AI metadata in the file and lists the song in a public opt-out registry as well. AI developers, crawlers would encounter the song file, check the metadata and the registry, and see that the rights reserved tag and must skip it or seek a license. The developer potentially wants to use it and contacts the rights holder to negotiate a license and a fee, and then the license terms could be logged and usage allowed. Other opt-out options proposed include public registries, as mentioned, of reserved work. So, for example, you may have a central public registry, such as the UK Intellectual Property Office, or another body could host a database of works and rights reservations, and the AI developers would be required to check their crawlers against this registry before training. And again, contract clauses in publishing or label deals where there's a rights reservation term in their own agreements, as mentioned earlier. For such an opt-out reservation of rights system, it is proposed that there would need to be really robust legal duties for AI developers. This would include an obligation to check for reserved rights before using the works, and a prohibition on circumventing technical measures or stripping metadata. As well as record keeping, developers would need to keep logs showing how they respected opt-outs, and a strict liability using a reserved work without a license would mean copyright infringement. Enforcement of this could be by injunctions, and remedies could be damages or account of profits, with a possible regulator oversight by, for example, the UK IPO could perhaps audit compliance with penalties for systematic breaches. However, with all these things, there are challenges and risks. There's potential for technical evasion. Some AI developers might ignore metadata or scrape from platforms that don't pass on rights information. There is also, as we mentioned, a global mismatch. If an AI developer trains outside the UK rights reservation may not be enforceable internationally. There is an active administration burden where creators must actively reserve rights. So there's a risk of default silence being treated as consent. And there are proof problems, as we also mentioned earlier, difficult to show that a specific AI output came from infringing training data. So under such opt-out proposals, as we said, if creatives don't opt out, AI developers can use the works without permission. This flips the current UK law, where commercial use needs a license at the moment. This flips it to an opt-out model. This is causing much debate. Many would prefer an opt-in system, where only if creators explicitly state that they allow use of their works for input training can their works be used. And if this is not stated, then the works cannot be used without consent. There are also potential international copyright law and domestic GDPR issues here with an opt-out system. So looking a bit more at, many are pushing back on the opt-out system proposals. Initiatives such as the Make It Fair campaign, which you may have heard about, launched by UK creative industries, point out that this, as we said, puts the burden on creatives to police their own work, and that tech companies should not profit from stolen content or use it for free. They're arguing for a fair deal for artists and writers as essential for the future of creativity and AI and the livelihoods of creatives. So if we look a little bit more at a potential opt-in system, currently right holders grant digital service providers, for example, a license to make their music available on a streaming platform. There are proposals that as part of licensing agreement between the DSPs and the rights holders, there should be an opt-in mechanism, allowing works to be used in AI-generated content if they are happy to do so. This could be subject to chosen specifications or limitations. For example, the AI tool developers could be allowed to just use the music or the lyrics from certain songs for training, but not the voice, for example. And also this would be subject to fees. The DSPs might then have a separate AI use cleared catalogue that could be available to AI creators with a set of guidelines of what they can use and how they can use it. Otherwise, the music gets taken down from streaming services, for example, as with uncleared samples now or copyrights infringing music. So the debate continues, hot topic of conversation as to possible ways to deal with input training and licensing. The next slide, please. So hot topic number 2, as we mentioned at the beginning, is outputs of AI-generated music. As a musician and creative, you may be using these kind of tools yourselves already. Intellectual property and authorship in AI-assisted and AI-generated works is another complex issue and another current hot topic of debate, as I said. Questions over ownership and whether AI generated music can be protected by copyright. Traditionally, copyright law has revolved around works created by human authors, showing originality in the UK through skill, labour and judgment. The right is automatic once fixed in a tangible form and does not need to be registered in the UK. In some jurisdictions, a work must be the result of human creativity to qualify for copyright protections. This is where AI complicates matters. So once an AI tool has generated a piece of music, can copyright subsist in it, and who owns it? The developer, the user, both? AI tools have no legal personality and therefore cannot be the author or owner of the work. In the UK, we do have provision for computer-generated works under Section 9.3 of the CDPA. Under this provision, copyright ownership could lie with a person or entity associated with the model or process, but there are important caveats. Excuse me, so let's take a look at these. Human versus machine contribution. This is the next slide. Oh, sorry, thank you, Ella. So for fully AI generated works where there is no significant human input, these may not qualify for copyright at all in many countries. In the UK, the law currently recognises the author of a computer-generated work as the person who made the arrangements necessary for its creation and gives protection for 50 years. But this provision is under increasing legal scrutiny. There is continuing debate over who is deemed to be the person making the arrangements necessary in relation to AI-generated music. Is it the owner of the AI tool, the user, or both, as we mentioned before? Works deemed computer-generated under Section 9.3 may not attract the same moral rights, and they raise tricky questions about originality thresholds required for copyright protection and first ownership. Academics and practitioners have urged legislative clarification, which seems to be a recurring theme here. For AI-assisted music, where the human makes creative choices, edits and directs the AI's output, is more likely to be protected by copyright, as the human contribution can be considered original authorship, or could be considered. If a human exerts sufficient creative control, prompts, edits, selection, human production, the output may be a conventional copyrighted work with a human author rather than a computer-generated work. However, determining that line is factual and it's often contested. Assuming that copyright does subsist in the output, then who owns the work generated could be clarified by contract. There is still much debate over the computer-generated works provision in relation to AI, and we will look at this a little further, a little bit later on. So then once you've created your output, there is also a risk of downstream infringement. Even if the AI output is new, in inverted commas, it can still infringe if it reproduces a substantial part of a third party's copyrighted recording or composition. Rights in sampled material or in distinctive melodies and lyrics remain enforceable, and you would expect to see rights holders pursuing takedown or infringement claims where outputs imitate identifiable pre-existing works without permission. Another point just to mention here is that there is a matter of copyright in the sound recording of the AI output, which often gets overlooked. Sound recordings are protected under English copyright law, regardless of whether they are created by AI or not. And next slide, please. So for creators using AI tools and licensing, what are the proposals about licensing outputs? Licensing and commercial use of AI-generated music is still a developing area, presenting challenges, and there is still, again, much uncertainty. If the music is subject to copyright, the copyright holder could authorize its use through licensing agreements, and some considerations here include which AI tools are being used and whether their machines have been trained responsibly, respecting the input of copyright owners' rights. And again, as mentioned, who owns the rights? In AI platform terms, some claim ownership or restrict commercial use. Clarity is required. Creatives may consider documenting their creative work and contributions to any AI-assisted works, and it may be possible to agree contractually who owns the rights. Another consideration is whether the new output potentially infringes copyright, as mentioned earlier, and whether you need to seek a license in this regard and to credit appropriately. I think the main thing to do here is to keep an eye on the changing legal landscape in these areas going forward and to stay informed. Next slide, please. So, let's now have a look at the future of copyright in music and AI and some points to consider here. Some tech companies, unfortunately, are arguing for copyright to be scrapped, but copyright provides an essential stream of income for creatives and their livelihoods. So many are calling for reform to the current laws, protecting copyright to clarify its scope in this AI era and to ensure a strengthened, robust framework to work within. Clarity is sought in relation to many issues, including defining originality in the context of AI, in relation to AI-assisted and wholly AI-generated works and whether copyright subsists. Clarity on authorship, specify who can be considered the author in cases where AI tools are used, and having clear labelling of AI-generated work so that it is clear to all how the work was created. The UK is also actively considering changes, such as the opt-out system, which we mentioned, which would essentially flip copyright on its head, so that creator has to actively do something to prevent use rather than having usual permissive provisions where user has to actively seek content to use. And it's also considering the possible removal of Section 9.3, the computer-generated works provisions. There are some potential pros to this for human creators, the removal of the computer-generated works provisions, that is. This could potentially mean less corporate lockup of AI outputs and reduce saturation of markets with copyright monopolised AI content. It could strengthen human creators' market position. If only AI works are public domain, then human-made works may stand out as protectable and licensable. There could be fewer grey areas where human creators are sidelined by being told their contribution use was too small and the company owns it instead. However, there may be no fallback protection if your AI-assisted work is judged too machine-heavy. You may potentially lose all copyright, and it is harder to monetize low-input AI creations if others can instantly copy and resell it. The abolition of this provision would bring the UK closer to the US, for example, where works without human authorship get no copyright. Others are in favour of keeping this provision, but calling for clarification of its scope. For example, the provision could be adapted the duration of protection limited. It could serve as a related right, and offer limited protections for fully AI generated works if it's within a clear legal framework. It could be kept separate to human created content, for example, with human created works remaining front and centre in copyright law. The UK is also looking at stronger transparency duties for AI developers and looking at the challenges around harmonising with international laws. We may eventually see new unique rights for AI generated works to try and balance innovation and protection for human artistry. The next slide, please. So, as well as legal issues, using AI in music isn't just a legal issue, it's also a matter of trust and integrity with professional and ethical responsibilities. It is argued that users or anyone involved in AI should be transparent about their AI use in their works. They should avoid deception. Misrepresenting an AI composition as entirely human-made, for example, can harm reputation. And they should respect others' rights, avoid infringing works or copying distinctive artistic styles without consent. Some parties, especially in the film, advertising and library music, now demand contractual warranties that AI content won't be used without disclosure. Next slide, please. There are other issues that we will just briefly touch on here, which a lot of you may well have heard about, deepfakes and voice clones. There is a growing rise in the use of AI-generated likenesses and voice clones in music. For example, in 2023, an AI-generated track, Heart on My Sleeve by Ghostwriter, imitating the voices of Drake and artist The Weeknd, went viral on TikTok. In the UK, currently, there are no standalone image rights, personality, likeness, or voice rights. Other laws have been used in such cases where there has been such use without consent. For example, the laws of passing off, misrepresentation, trademarks, privacy and data protection, and contract law, and sometimes performers' rights and moral rights. However, these are not always helpful or workable for such cases. For example, passing off may not have been suitable in the situation of the Ghostwriter example, where there was no reference to Drake or The Weeknd and people knew that it was AI. Some are calling for a new image and likeness right in the UK, as there is nothing to protect properly at the moment against deepfakes and voice clones. Any such new right could, for example, be a personal, non-assignable, non-waivable right of individuals. So lots to take in there, but in conclusion, whatever your thoughts and fears about AI, it looks like it is here to stay and remain a force in music. It can offer unprecedented creative opportunities alongside serious copyright and licensing challenges. I think we are all facing a rocky road ahead as this era develops. There is still a great deal of legal uncertainty. Possibly the most successful way forward for all concerned in this area would be for both AI developers and creatives and right holders to understand the evolving legal framework, negotiate licenses for inputs and be clear on ownership for outputs, maintain transparency in creative processes, and advocate for policies that balance innovation with fair reward and aim for a system where AI enhances human creativity rather than replaces it. Hopefully, this evolving landscape will lead to a clear, robust legal framework giving certainty to both AI developers and creatives, together with control for the creatives over their works and fair remuneration. Thank you very much, and I'm very happy to take any questions. I'll just hand back to the team.
Thanks, Charlotte. That was fantastic and very informative. Yeah, please do get your questions in, everybody, using the Q&A function or the chat option. We have a few in already and a few pre-submitted, but don't be shy, ask away. To start off, let's go to a pre-submitted question. Does AI have the ability to direct PRS funds directly to composers or writers or bands?
So I think this means in the context of tracking
I think so,
public
yeah.
performance, royalties and uses. So I mean, I'm not an expert on that kind of AI and how that works, but I think potentially it could analyze a lot of data very quickly, track where copyrighted works have been used, and assist, I think, with collecting that or sending the information. So I think maybe at the moment it could assist and help streamline that process, but I think you'd still need the PROs that are like PRS to make sure the money comes in and then is distributed fairly.
Great,
So
thanks.
potentially.
We have one here. If an AI generated song sounds like mine, how do I prove originality or infringement?
The $1 million question. Yeah, it's a really difficult area. As I was saying, it's really tricky, and it's often on a case by case basis. Has a substantial part been used, and it's really difficult to, as we were saying, prove if your work has been used for copyright training. But if the output does sound like yours, then I suppose it would potentially be just as in a normal copyright infringement case, where you can show that you've prior created your works and the similarities and put the potential infringer on notice, and then take it from there in a normal legal way.
Great. We have one here. So if I want to use Suno to create music, and it's probably ties in with 11 Labs as well. I don't know if you see their new Merlin and Cobalt deal where they've licensed to 11 Labs as a platform. But if I want to use Suno to create music, can I earn royalties on the output or not?
So I'd probably need to know a little bit more about the terms and conditions of Suno and how that works. But I think it's about looking at the terms and conditions and whether yours is AI assisted work or completely AI generated, and then deciding it may be contractual. I don't know how it works with Suno, whether you do separate contracts or you just have to work under their separate terms and conditions. But it's all about looking at the small print really and seeing what's involved there.
Great. Here's another one from an attendee. Is there any point in reserving rights and updating metadata or even agreeing to licensing if rules are different in every country?
Yeah, again, it's such a tricky question at the moment, and that's why it's a shame that everything's taking a long time to catch up, because this is going on already, and developers are using works, and even if there's a reservation of rights, and there's so many different ways of doing things in different jurisdictions, and digital streaming is global. How is this actually going to work in practice? So I completely understand your question there. Is it really worthwhile? And I think that the sooner that the government and law can work out a way if this is going to work fairly, then the better. Because at the moment, everything is up in the air, a bit like when sample links became a big thing, or Napster was file sharing freely. Everything is up in the air, and we need a legal framework that clarifies how you can be protected properly.
Yeah, that's great. We've got a pre-submitted one here. How do I negotiate a licensing fee for a song with an AI company? And I suppose this also has to take into account that the AI company might be using your music in perpetuity, and how do you license for such a thing?
Yeah, so again, it would depend on the what terms and conditions are going on with the AI developer. They may already have some set terms and conditions, and I would make sure you know what those are. They may have draft licenses that they send over, which hopefully you can negotiate. Ideally, you would be able to have a say in, say, how long they could use it for, how they could use it, what approvals they might need. But ideally there would be some toing and froing rather than you're just stuck with some set terms that you have to put up with.
Here's an interesting one. We did a survey recently trying to see if anyone had done any licensing deals, and it was hit and miss if they'd actually happened between AI companies and publishers or music creators. But as a music and media lawyer, have you had to deal with any of these issues around AI yet?
So I've done some rights reservations, but actually dealing between AI developers and rights holders, not so much, to be fair, because I feel as though people are waiting
Yeah.
and they don't want to contractually set themselves something in stone yet until they are clearer about where the law is going. So everyone's almost holding off, I feel, but there's a danger then that the music is still being generated and used without any proper contractual provisions in place, without knowing the law completely, and the law not knowing itself completely yet. So yeah, there's a danger that things are going ahead, and then once the law is set, hopefully, what happens to those ones that have gone ahead already? So yeah, Glenn, it's not a satisfying answer, to be honest, but it's just the way of the landscape at the moment.
Yeah, just on that, regarding rights reservations, is that a case of someone coming to you and trying to reserve their catalogs rights for training?
Yeah, so it might be, for example, a songwriter doing a publishing deal and they're
Hmm.
reserving their rights within that deal so that a publisher can't then go off and say, license the whole catalogue of songs to an AI developer. So, or again, an artist and their recordings with a label, they're reserving rights in their contract saying you can't go off without my approval and just license these for AI use.
And are publishers happy enough to agree to that, or is it a
It's the
challenge?
ones that I've come across so far, yes.
Okay,
Yeah.
interesting.
But whether that will change or not, I don't know. So as long as, I mean, it's not saying they can't do it, it's just saying that they need to get approval first. Yeah.
Right, right. Here's another one. If a US or Chinese company trained using my music, is there anything I can do about it?
Yeah, so again, this is really tricky, and I think this is what's happened with the Getty case at the moment, is that they've not been able to show that the use happened in the UK, so they've had to withdraw parts of their claim. Um, yeah, different jurisdictions, different laws. I think that's just a developing area. It really is a developing area, and I wouldn't like to say one way or the other what to happen there.
Right, we've one here. AI generative applying law depends on the country where the AI is located or on the country where the user is. Do we know? So is it, I suppose they're asking, is it the country where Suno or the platform is
Yeah,
located,
or
or is
where the
it
user
you?
is.
Yeah, yeah.
So yeah, that I think that's still a bit of debate as well because they're trying to what's still up in the air is where the copyright subsists, who it subsists with. Does it subsist with the AI developer? Does it subsist with the user? Does it subsist with both? So
Hmm.
because that's not being completely established yet, then I think it's difficult to say where an infringement might have taken place.
Hmm.
There's another issue around that as to would it be with where the AI company is based? Is it where it's with? Is it with the user where they're based? Is it a bit of both? Still a question to be clarified.
Great, great. We have a combination here of a few different questions, but we've one. What are the best practices for using AI ethically as an independent artist? And another one, which is on the same vein. While the law is so unclear, until there's a better way to opt out or license, what's the best thing I can do to protect my music? So just
Yeah, I mean, I've been
protecting
having to
myself.
think about this before I came onto this, and I think um, because it's so unclear, it's really tricky. I think um, the best way to try and protect your music, because if you're trying to protect it from being used in training, then really you should already be protected in because they need a license to use it at the moment in this country. But as we can see in practice, that's not really happening. So I think it's about sorting out licenses yourself if you can with anyone who's using or potentially using it. Not always ideal, but not all possible. And campaigning for some strong, robust framework in this area. And then if you are using AI generated works, then I think it's about trying to find out if they have done the training responsibly, and about determining yourself with the AI developer who is the owner, if copyright potentially does subsist. But because these are still unclear questions, I don't think there's a completely right way to do this at the moment. And that's why it's so urgent to get this robust framework in place.
Yeah, great. And the ISM are campaigning on those issues, so keep up to date with what's going on here. We've one here, and this kind of touches on recent events with WeTransfer and Adobe and the likes of that. The digital distributor I use to release my music has changed their T's and C's, and now it looks like if I upload my music, they can sell or use my music as data. Is there anything I can do to protect my music, or should I use a different distributor?
Yeah, that's tricky if they've changed it midway for you using it. But I would contact them and find out if you are able to reserve rights there and stop them from using your works if you don't want them to. And if not, you may need to look at changing a distributor. Yeah, it's such a fast changing pace at the minute. Everyone's looking at changing how they work. So yeah, I think it's definitely worth looking at ethical responsibilities here and changing to people who aren't using works without consent if you possibly can.
And just a few questions about publishers and clauses around AI. Is that something you'd recommend if someone's approached with a publishing deal or contract to have a discussion about an AI clause of some kind?
Absolutely. Yeah, I really would. I mean, there's so much lack of clarity at the moment that if there's anything that you can clarify, then definitely do it. And you can in your publishing deals or your record deals, you can ask for clauses for rights reservation and approvals on any use. And they are expecting that, as far as I can see. Publishers are expecting that. So I would definitely ask for it. If it's the one thing you can do, then do it.
Yeah, we have a question just in here, and it's a horrible question. But I suppose pointing at that, it's about taking the initiative yourself, if you can or where possible. But the question is, how long is it going to take to sort out the law all over the world? Do we have time to wait?
That's a big question. And
Yeah.
I do remember this back when music went online and more than physical product, and when the sampling became this big trend and samples were just being used freely. Um, it did take a little while, and there was a little panic in the air, but it did sort out. I can't say how long it's going to take, but I do feel that it will have to harmonise because of digital global use of music, and it will have to happen soon because if if it doesn't, then creators aren't going to get remunerated, and then who's going to want to bother to make music? I think I think there will have to be a fast moving way of solving this. I
Mm.
can't say how long. I'm sorry.
Yeah, yeah. It's like the start of streaming. If you asked that, you'd
Yeah.
you wouldn't have said yeah. Um, we've one more on the technicality of it. Can you explain more about why training data may not constitute copying, and why is a copyright exemption required for training if it's not copying?
Yeah, I mean, this is just an argument that's been put forward. Hopefully, it's not going to be taken seriously at all. But some people have put forward the argument that it's so transient and it's analytical and it's not actually copying. But I think that view has not been taken on board so much because even a temporary copy can still be classed as copying. So hopefully that's not going to become an issue. I just raised it briefly as that has been put forward as an argument.
All right, we have a few more. Um, can AI companies keep track of the works or training data they are using, or are they choosing not to?
I think I'm sure they should be able to. I mean, they've got all this investment in the development of AI, and they must be able to know what works they are using, and that's why they're calling for transparency on the works that they have used or are using. It's just perhaps there are AI developers that are just going ahead anyway, whether they've got consent or not. There's a lot of money to be made, and for some, copyright is not a concern, and they're just looking for a way to develop this further and further. But I don't see why they should be able to do that without compensating the people whose works they are using.
And then finally, do you think it's likely that the UK will introduce personality rights?
I think it's becoming more and more possible, as in image and likeness rights. It's in the US, for example, and I've long thought there are ways of dealing with these issues with a multitude of different laws for passing off or misrepresentation. They didn't even work before AI very well. So I think with AI now, there's a strong argument to have these image rights, which could protect, for example, celebrities or others much better than we have at the moment.
Great, fantastic. Thanks a million, Charlotte. That was very informative. Thank you for everyone for attending. We have one final question which says, are the ISM involved in this campaigning? Thank you for that question. So yes, we are. We've run this webinar series. We're going to send this webinar along with the slides and a link to the last webinar, which was working as a musician in the age of AI, which we talk about using AI and what is ethical and different plugins and what is the future of the career in music. Thank you for everyone for joining. Keep in touch with the ISM. If you're looking for legal advice on anything to do with AI, please do get in touch with our legal advice team. And looking forward to seeing you all at the next webinar. Thanks again, Charlotte.
Thanks very much for having me.